Right. Good afternoon, everyone. Welcome to the last quarterly webinar Hicksons will be running for the year. My name is Alex. I'm an associate in the Workplace Relations, Employment and Safety team here at Hicksons. I will be emceeing our panel discussion today on the topic, is the law letting employees off the hook for owning their own actions? With me, I have Warwick Ryan. You may well know him. He heads up our workplace relations, employment and safety team with over 25 years experience in the industry. And he's also currently a lecturer for the Introduction to Employment Law Master's course at UNSW. We also have Hazel Millar, HumanX employee relations business partner. Hazel has extensive experience in guiding businesses and leaders through a wide range of employment matters with experience spanning various sectors, including media, passenger transport, and freight. Hazel's passion lies in devising practical employment solutions tailored to each business's unique needs, enabling them to achieve their objectives. And finally, we have Karolina Dobson, head of SafetyWorks. Karolina is a psychologist specialising in workplace health, safety and wellbeing. She partners with organisations to address complex people challenges, embedding a culture of health and safety across all business areas. Karolina helps organisations achieve their goals by focusing on organisational design, strategy development, cross-functional integration and culture transformation. So thank you both to Karolina and Hazel for giving up your time at a very busy time of year to talk on this topic with us. We chose today's topic because it is a common issue our clients are grappling with when it comes to managing employee behaviour in the workplace. In short, the law is trending in such a way where an employee's personal responsibility is becoming less and employers' responsibilities are only increasing. And this is not a trend that's going to change anytime soon. The high expectations imposed upon employers at law emphasises the importance of getting your workplace framework and leadership right to mitigate legal risk. So today, we're going to unpack some of those complexities around responsibility in the workplace and hopefully offer some insights into how to manage challenging employee behaviour. We've got a lot to cover, but you can see on your screen there's a Q&A function at the top. If you have any questions, you can put them in there as you go, and we've dedicated some time at the end of the session to answer those. If we run out of time, we can always come back to you in writing afterwards as well. So without further ado, my first question is for Warwick Ryan. Warwick, we are going to be delving into some murky parts of the law and workplace relations today. Can you briefly explain what we know about where an employee can be held personally liable for their behaviour in the workplace?
Absolutely, when I get off mute. Okay, so there's a range of options, I guess, for individuals to be held liable, both by potentially by an employer, but also by other people, fellow employees, and in fact third-party individuals can also can make claims against employees in a range of circumstances. So first, starting with the employer, if an employee has an obligation under their employment contract and they breach that, then normal contractual principles follow. So an employee can be held liable and in fact pay damages, and there are cases to do with that. Most notably, there was a case in Queensland to do with a driver who basically turned over a vehicle, a semi-trailer, and while he's using a mobile phone, and the employer sued the employee for the value of that. So that's one option. But a lot of the time it lies in legislation. So under the Fair Work Act, Section 550 has 4 separate headings, which essentially it's an aiding and abetting kind of range of and complicity menu of options for both employers but more particularly those who are aggrieved under the Fair Work Act to make a claim directly against an individual who was involved in whatever the breach is. Under the discrimination legislation, individuals can be joined as parties if they are in fact in breach of that legislation, and that's quite apart from their position, any claims in tort that may otherwise be made against them. Their claim in tort, they're shielded from that by, in New South Wales, by the Employees Protection Act, but under the discrimination legislation, they are liable. And of course, under work health and safety, they can be prosecuted both as officers, as defined under the Corporations Act, and also just as individual workers within a workplace. They can be held, found liable. They can be convicted, I should say, under the Work Health and Safety Act, and in fact, fines and penalties imposed upon them. And most recently, of course, with the changes to the legislation regarding industrial manslaughter, there is a liability for certain, certainly directed mainly at officers in companies, but to be held liable in that circumstance and sent to jail, convicted and sent to jail. So that's kind of a bit of a smorgasbord of ways in which individuals can be found liable both civilly and also criminally.
Okay, thank you, Warwick. I want to preface by saying that's probably the clearest answer we're going to be able to give on the law in this seminar, and now we're going to move more into the murkier parts of the law. So on that note, Warwick, there were a couple of quite notable decisions that have recently come out of the Fair Work Commission that were quite surprising for employers and really spurred this discussion internally for us about what this means for employers and employees in terms of that personal responsibility piece. Can you explain a bit about those cases and why they were so surprising?
Yeah, okay. And I'm hoping I don't turn this into some sort of teenage rant. Fortunately, we've got some voice of reason here with both Hazel and Karolina here to avoid that, keep me on track, but keep this discussion on track. But what I've seen, particularly within, I'm going to focus on the Fair Work Commission. I've also read decisions in PAC, which is the Workers' Compensation Commission, where I've walked away and shaken my head. But I'm not a workers' compensation lawyer, so I'm not going to stray too far into that, and I'll let others make comment about those decisions. But certainly in relation to the Fair Work Commission, when they're dealing with unfair dismissal, it has seemed to me that there has been this creeping trend to impose upon employers an obligation to educate staff in what would seem to be the most elementary behaviours that people should exhibit in public, in any circumstance, and that where an employer cannot highlight that they have taken steps to educate their workers on basic human conduct, that somehow or other that employee, well, not somehow or other, that employee has a remedy at law against the employee where the employer has terminated them for often quite egregious behaviour. And then, and the kind of the subtle other aspect of that is that there are certain expectations of individuals within a workplace that you would think that they would be able to exhibit as adults, like any person, to conduct themselves, to get through life, which somehow or other they are excused from showing any agency in that space. And again, the poor old employer is left with having to cough up a remedy to an employee who has showed, the behaviour of a 3-year-old. So that's kind of the background. I read these cases, I tear my hair out, I close the office door, and I have a rant and a bit of a yell, and then I try and compose myself and go on with my day. So that's the context. But if I can just take you to a couple of cases that really, can I just say, annoyed me. One of them was, it's seemingly a benign throwaway comment by, I'm not going to even mention the commissioner at the time, and I'm not going to mention the case names, because I want them to be indicative rather than to single out the particular adjudicating officers in these cases for the Commission. One of them was involving two individuals who worked side by side within it was a club situation. And they started off as good friends. Their relationship soured. They had no supervisory functions over one another. They previously worked very happily together and got on, and when it deteriorated, they engaged in behaviours which were infantile. They were abusive to one another at various, on occasions, they even kind of pushed and shoved a little bit with one another. They just behaved like teenagers at their worst. Now, the employer took various steps to try, took the step of trying to separate them and put them on different shifts to avoid issues, but issues persisted and one of them was terminated. Now, I don't want to go into the details of the termination. There were some flaws in the process of that termination, in the procedure. That's not my focus. What stood out for me was the fact that the determining officer, in this case the commissioner, made the comment that the employer should have set up some form of mediation between these two individuals as adults, to try and help them get on with one another as friends. Surely it is a prerequisite when someone goes into a workplace as an adult that they can manage relationships. And if they can't manage relationships in a workplace, there's a real question as to why an employer should continue to employ them. Surely that is a threshold responsibility upon someone in a workplace just to be able to have some basic skills at relationship management. Now, in this particular case, as a result of these poor behaviours, the employer ended up having to pay out to the individual involved, even though both of them, to be fair, behaved very badly in this situation. It is just unreasonable, and I think it's a real problem if you're looking at someone who's going to invest capital into a workspace and essentially have to treat their employees as children. That's case number one. I'll try not to go on too long. The other one, which even annoyed me even more, this was a case where an individual in a workplace engaged in a course of conduct of belittling a workmate using highly sexualized terms and highly sexualized gestures on repeated occasions to demean and humiliate his co-worker. And this occurred over a period of time. And when the individual pushed back on this, on which he did on a number of occasions, the offending employee, I think the phrase is, gaslighted him and said, "Oh, you can't take a joke." If I read out the comments, I said to the team beforehand, should I read out what was on the public record? And they said, no, it's a bit too grotesque, so I'm not going to do that. But it was that offensive. Still, and in fact, during the course of the hearing, the individual was terminated by the employer. During the course of the hearing, the offending employee showed no remorse and didn't refuse to apologise. So engaged in a course of conduct, was humiliating and belittling in an age of depression and suicide and what have you within workplaces where bullying's well regarded. Gaslighted the individual when they tried to have them stop, and then furthermore refused to apologise. Ultimately, what was found by the employer was that by the adjudicating officer, was that the employer had not adequately rolled out the policies in that workplace to curb this behaviour. And had they had some policies, then this individual would have been a different person and would not have engaged in this behaviour. Again, it's a situation, at what point do employees, are they held accountable for their behaviours in a workplace? I don't think there is anyone in the country now who does not understand that bullying is a real issue and it has an impact upon individuals' well-being. And if they don't understand that, they really shouldn't be in workplaces. But on this occasion, the employer ended up having to pay out $33,000 in compensation to an individual who, had they been prosecuted under the Work Health and Safety Act, would have been found guilty, out cold, no doubt about it, and would have in fact been fined possibly tens of thousands of dollars personally. Had the individual, the other employee, made a claim under the Sex Discrimination Act, it would have been a claim both against the employer but the individual. But still, the individual was forced to pay out tens of thousands of dollars. I will shut up. One more brief comment and then I'll let the others speak. The recent cases, and there was a decision at first instance where an individual had used cocaine, come to work, and there'd been a whole argument about whether employers had to demonstrate impairment before they could terminate someone. It went to the full bench. The full bench went most of the way to reversing that, but they left the door open. It was a really classically poorly constructed decision of the full bench, where they pretend to kind of shut the door and then leave it open again. But essentially, the question which I thought was a threshold question, is that in what universe is someone who is driving a train, that is their job, and I understand, and I have some information on this, train drivers are very well paid, comparably to many other jobs. Why is such an individual taking cocaine? And if they are taking cocaine in any circumstance in their personal life, surely they must be culpable. Surely an employer would not have to even think twice about terminating them if they had the evidence, obviously, of that they'd taken the substance. But again, we live in a universe where, in this case, the individual was reinstated back into the workplace, even though it had been found that individual had taken cocaine. End of rant. I'll let the adults speak and hopefully get more constructive solutions out of this.
Thank you, Warwick. You used a word there, paternalistic, and we have been throwing that around when we've been talking about this webinar and where the law is going. And where we've got to is that at its most conservative end, the law is paternalistic in the sense that you do have to be explaining what is abundantly obvious to majority of the workplace population. We're going to park that for now, and my next question is going to go to Hazel. Hazel, you are working with clients every day that are grappling with how to manage unacceptable employee behaviour in the workplace. Knowing that it can be risky to terminate those that don't know how to behave appropriately or can't get along with their colleagues, one of the ways to mitigate this issue is to make strategic hiring decisions and do your best to find the right fit for your organisation from the get-go. My first question to you is, how important do you think recruitment processes are in finding employees that are the right fit for your workplace culture?
Thanks, Alex. I might just start by saying that, Warwick, everything that you were just explaining in terms of the complexity of the practical environment that businesses operate in really resonates with all of our clients. These are sort of day-to-day issues that we're trying to navigate. And as you say, Alex, recruitment can play a role in, if you do that properly and you get the right people with the right cultural fit into your organisation, hopefully that mitigates some of this risk of them exhibiting these sort of really quite terrible behaviours. When we have a look at this, we're seeing all sorts of really cool, really innovative ways that our clients are trying to test for this. So there is a focus in recruitment at the moment on trying to look at the behavioural performance of individuals coming into the organisation. There's some really out there stuff happening with Atlassian and Telstra and these kind of bigger organisations where they do all sorts of gamified interactions to try to see how someone would react under pressure, how they might interact with colleagues. We're seeing some of our clients who have the sort of time to spend on this, doing some really interesting stuff like partnering a candidate with an employee. And this employee is a sort of a peer feedback loop that they're throughout the recruitment process, kind of having a two-way conversation with this candidate, even though they're not hiring them. And out of that is sometimes a bit more of that, the guard is dropped a little bit on the candidate side, and you can get a better understanding of how people might interact with colleagues once they're in the workplace. These are all really time intensive things, and they can cost a lot to set up. So the practicality of it is also quite challenging. Having said that, there is that really cool sort of innovative stuff going on, but we're constantly reminded of getting the basics right with recruitment. So even though these are really straightforward kind of things to do, the behavioural interviews, making sure that you do work assessments, all these sorts of things, we're seeing employers under time pressures maybe not sort of doing these as well as it could be done. And so we've had a few clients recently with all sorts of terrible outcomes as a result of the recruitment process failing. When it's done right, it can be really useful, but when it goes wrong, that's problematic. So we want to say to our clients, and this is something we talk about all the time, is to not rush these decisions. So recruitment can be a really useful tool in predicting this, how someone will behave in the workplace. And you often get this sense of kind of a bit of a gut feeling after an interview. But if that gut is telling you that that person's a wrong fit, don't rush. Start again. Don't go to the first person that you've got. Secondly, we'd be saying really focus on that cultural fit piece. So spend a whole second interview really challenging the candidates with behavioural questions that can help you draw that information out. See how they've reacted in other circumstances. Again, these are really basic things, but they're really important. We're seeing at the moment lots of people using virtual online Teams meetings and the like to do interviews. We want to remind people that to get these things right, it often can be a face-to-face that's going to help you make the right decision. We've had a client recently interview a number of times online, an outstanding candidate. They got into the workplace day one. It turns out that this person had a very severe substance abuse issue, which manifested as really terrible behaviour towards colleagues. And those are the sorts of things that you might be able to screen and pick up better through proper face-to-face or reference checks, those kinds of things. So recruitment can be a really good tool, but it's one tool in your toolkit. So it's not going to fully prevent behaviours from occurring once people are through the door. So importantly, and I guess we'll unpack this a little bit more as we go today, is that once somebody is in the workplace, it then becomes critical to make sure that you're educating them about your expectations of them at work. And it is the basics. It's that how to be respectful. It's all the do's and don'ts of interacting with colleagues. And we find that that part sometimes is forgotten. So we really implore our clients to make sure that they think about recruitment, not finishing at the point that someone walks in the door. Think about it as managing that probation period. It's part of your recruitment. Test someone's behavioural how they show up at work, and make sure you're managing that really tightly, because that's, if you can nip that in the bud and identify those issues early, you'll hopefully mitigate some of that risk of things really going out of control.
Thank you, Hazel. You raise a really good point there about utilising that probationary period well. There are so many times clients come to us and it was 2 days past the probationary period and they just turn their mind to it slightly late, and then it just creates so many more complexities for the client. My next question is for Karolina. So one of the key traits that an employee needs to be able to manage interpersonal conflict in the workplace and work well with their colleagues is emotional intelligence. Can you explain briefly what emotional intelligence may look like in the workplace?
Yeah, sure. So there's no agreed upon definition of emotional intelligence in the social sciences, but broadly, workplaces can be viewed as socio-technical systems in which social interactions are critical. And our ability to develop effective, meaningful, and successful relationships with others is really important. So in the workplace, if I think about an employee who would demonstrate a high level of emotional intelligence, or is generally agreed as such, would be someone who positively contributes to the team dynamics by showing up in a way that fosters trust and respect in all their interactions. They connect with others in a relational way rather than in just a transactional task-based way. They tend to have good insight into their own emotions and how these can impact on their own behaviour and that of others. They can generally identify quite clearly and articulate their emotions and take ownership of their emotions and actions. They can actively listen to others and really take in diverse views, opinions, thoughts. They have an appreciation for diversity of thought, and they can effectively, be effective in conflict resolution. They can manage disputes, interpersonal disputes constructively, and towards collaborative solutions. They're adaptable and they have a low need for certainty. So there's a fair bit there in terms of being able to be adaptable not only to different views and opinions and ways of thinking, but able to sort of navigate their own conflicts and be flexible, but demonstrate good mental flexibility.
Thank you, Karolina. That's really helpful. My next question is for Warwick. So the Fair Work Commission, Safe Work New South Wales, the Australian Human Rights Commission and the PIC have all made it clear in their own ways that an employer's policies are critical to setting expectations of employee behaviour, ensuring their workplace law compliance and defending claims brought against them under workplace laws. And bringing it back to the topic of our presentation, really being able to point to someone and say that they are responsible in the workplace a lot of the times is now being brought back to what's said in policies. So my first question for you is, what is the practical purpose and legal status of a policy?
I think, Alex, unfortunately for you, given the length of that question, I think you've been spending too much time with me. And I know my childish, and verbosity is rubbed off on you. There's really 4 sources of law that drive or that form the employment arrangement in Australia. I'm going to leave out government employees and local government employees in a bunch of states, and in some states it's not the case. But the Fair Work Act rules the universe of employment by and large, and it applies to almost all employees. So that's one source of law. And there's then you've got awards which fall out of that, and they set a whole bunch of minima and bottom line behaviours or rules that would apply to the way largely employers treat employees. Contracts of employees, which they pre-existed, both of those. they are individual binding agreements that impose responsibilities both on employees and employers. Predominantly, they're drafted by employers, so they are generally about what the employee has to do, generally. And there's rights to compensation that employees have under that. There's rights for both parties to sue where there's a breach. Policies are really a creation of the last probably potentially 20 or 30 years, more 20 than 30. Under employment law, there's always been a right for employers to give lawful directions. And a policy is essentially a lawful direction written down. So rather than having to tell employees to make sure they clean up their kitchen after they use it at lunchtime, they put it in a document. Once upon a time, they used to put that document on the office notice board, but we don't live in a world in office notice boards anymore. These policies have been documented, and now they used to sit in folders on the shelf. Now, of course, they sit on intranets, and we set out the framework for behaviours generally within a workplace across a whole range of areas, from how information is managed, how people treat the physical environment, how people treat one another, how people treat customers, what the privacy issues that exist, and of course the behaviours that people must exhibit around safety. So there's, just amongst that, you've got a very significant amount of information, and they are, because they're directives, they don't need the consent of the employee. In some circumstances, employers need to consult their employees before they introduce them, because awards say that you should have consultation. But they're really just directions by employers to employees to behave in a certain way. And increasingly, those determining bodies have decided that policies are, to some degree, the be-all and end-all for employers, as in the way they, if employers want to direct employees to do anything, and that anything outside a policy is not given significant regard by Fair Work Commission, for example. So, that's the world of policies.
Thanks, Warwick. And my follow-up question to you was, what policies do you consider should be the bare minimum in a workplace?
Okay, well, there's a number of legislated policies. So, for example, SafetyWorks New South Wales put out a directive. There was a code in relation to psychosocial safety. They issued that a couple of years ago, and that gives certain directives in relation to policies that should be maintained within workplace around that. There are a number of other codes of practice by SafetyWorks New South Wales, which again cover different areas, such as working at height, dealing with forklifts. There's a range of those areas which should be have policies attached to it. The privacy legislation imposes certain responsibilities in relation to managing the information of clients and customers. So that's another area in which there will often be a policy. So out of legislation, you get certain obligations upon employers to have policies. Beyond that, I think you'd have to say, because of my rant earlier on in this presentation about, what the Fair Work Commission requires employers to do, I think inevitably you kind of have to run up the white flag and acknowledge that if an employer wants employees to behave in particular ways within a workplace, the only way they can be safe in the knowledge that they'll get some support from any of these determining bodies is if they put it in a policy. So, so whatever is important to an employee as far as workplace, to an employer as far as their employees' behaviour within the workplace, they really should put in a policy. Otherwise, they leave themselves vulnerable if they want to introduce any level of accountability within the workplace.
Yeah, okay. Thank you, Warwick. My next question is for Karolina. How important is leadership in setting the tone for employee responsibility?
It's crucial. The actions of leaders really impact on how responsibility is perceived by the workforce, how it's adopted and enacted in the organisation. It's really, really critical, the role of leaders.
Okay, thank you. Yeah, and I suppose just from a legal perspective, that flows through into our case law that we see as well, in the sense that leaders and managers are held to a higher standard, and you can, at law, expect more from them, particularly if they're doing things like bagging on the employer or not role modeling what's set out in policies. My next question for you is, how can leaders effectively model accountability and encourage it through the organisation?
Yeah, well, given that Warwick was speaking to the importance of policy, they can encourage it by integrating accountability into organisational processes and embedding the policies within teams. That's a gap that we often see. So really cascading those key messages around the parameters of acceptable behaviour throughout the matrix of the organisation is something that is not that often done from our experience. So policies that sit on the intranet are really not fit for purpose. People, if they don't know about the policy, if they don't know that it exists, it's not fulfilling its purpose. So, leaders are responsible for that. And, in terms of role modelling it, if we think about the word leader, it sort of derives from Old English roots, laden, which means to guide and to bring forth. So leaders that are effective in setting the tone for employee responsibilities guide through their own actions through influence, and they help by, walking the talk. So the greatest impact that can be made by leaders is through ensuring their behaviours are aligned with the espoused values of the organisation. Their behaviours are aligned with the policies, processes, procedures, and they're modelling responsible behaviour themselves. They're owning their choices, including their mistakes. They're aligning their actions with their words. They're following through. They're avoiding ambiguity and communicating with the workforce. They're setting clear expectations, and dealing with a lack of accountability promptly and constructively. To what Hazel was saying earlier, making sure people are held to account early, from the get-go. One of the common situations we see is that we have an employee who's presenting with counterproductive behaviours, or underperforming, but let's say, given the topic, counterproductive behaviours, they've been somewhere for years, and then you get a really proactive manager come in down the track, and they start to hold the employee to account. And all of a sudden, because perception drives reality in this space, all of a sudden this person is perceiving that they're being unfairly treated. So, dealing with that lack of accountability early, and really integrating it into the processes is really important. And the other role that leaders, I feel, really have is to convey important messages about personal responsibilities. So I think leaders need to really project a balanced view between individual rights and what I'm entitled to, seems to be, really coming through, with responsible thinking towards collective purpose. So what does this situation require of me? How do I need to show up at work? And so, in doing that, I think that helps, get some of the way from the point of view of a leader. Yeah.
Thank you, Karolina. That was really insightful. I actually have another meaty question for you. It's twofold. How can an employer better understand the root causes of negative employee behaviour? And how can an employer address the root causes of negative employee behaviour?
Yeah, that is a really meaty question, because, the drivers of negative employee behaviour and just human behaviour in general are complex. They're many and varied. So simple cause and effect relationships, seldom exist. So And also, if human behaviour is complex, so too is the interpretation of behaviour and the lens through which it's viewed by others. So it's important to recognise that, you know, negative behaviours can be a manifestation of lots of things. So it could be issues to do with capacity, capability, competence. There can be misattribution of meaning, you know, intended meaning versus how I've interpreted, you know, clashes of personality, different personal appetite for challenge and argument, really lots and lots of things. The culture in which someone grew up in, so including national culture, you know, in some parts of the world, argument, proactive conversations to argue and towards, you know, the betterment of problem solving or towards truth are actively encouraged. These are seen as signs of caring, intelligence, and wanting to work towards the common good. So, and other cultures are high on agreeableness and very aversive to conflict. And then there's also, you know, family of origin. Were issues swept under the carpet, or was there lively and spirited debate at the dinner table? And how are people sort of viewing that? So when it comes to the impacts of interpersonal interactions, perception drives reality, where the individual on the receiving end of the behaviour is the mediating factor that determines the extent of impact, which is why that risk assessment rating point can be so tricky with psychosocial hazards. The other thing is that, you know, if current data is to be relied upon, the background risk for mental ill health in Australia is high. So current estimates are at around 20% of people at any given point in time in Australia are impacted by symptoms that would warrant a mental health disorder, whether it's diagnosed or not. So as people are travelling along the spectrum from mental health into that mental ill health, into the realm of mental ill health, you know, prior to diagnosis and treatment, we might see some negative behaviours manifesting as they slide into dysfunction. You know, people can become irritable, just depending on what's going on for them. Irritability, they can become impatient, they can be showing up in ways that are really different to usual. And so that's an important one from a leadership point of view, because it really highlights the importance of knowing your people. How will you notice if there's a change in someone if you don't know them, right? So you need to be on the lookout. And the other thing is that people get away with what they can get away with. So again, it goes back to integrating accountability into your organisational processes, holding people to account from the outset. It's really important. So to address the contributing factors, which is the second part of your question, it's really about getting to know your people really well, being across the work and keeping your finger on the pulse in terms of the team dynamics, maintaining sort of visibility of all of that. The other thing is employers often become involved quite late in the piece when things have gone wrong for like a while. There's missed opportunities to address low-level negative behaviours like incivility, you know, conflict that's been mismanaged. It's not unusual for us to see that, you know, employers have become involved once there's an ethics claim, you know, there's an ethics point or there's a workers' compensation claim. Things have gone woefully awry for quite some time before it's really flagged. And the other thing might be slightly contentious, but the way that conflict is viewed in an organisation can make a difference. And I think employers do have a role to play here, because conflict can be viewed as inevitable and something that we're all expected to manage effectively. It can be a sign that people care deeply about the work, that there's different views. You know, there's a lot of talk about diversity and inclusion, protecting diversity of thought and being able to hold a conversation with someone you don't necessarily agree with. So modelling constructive conflict as a form of disagreement or debate that fosters diversity of thought and innovation, you know, in the pursuit of a better solution to a problem, that I think that can be a powerful intervention. So, you know, if leaders role model healthy conflict that's in the service of shared goals and model the skills it takes to navigate that well, you know, focusing on issues and not personalities, and you know, encouraging open communication, active listening, you know, respectful dialogue, and applying a problem-solving mindset, owning their behaviours and setting the parameters, you know, what's acceptable within within how we manage conflict. I think a lot of the answers lie there. Fostering that culture of trust and respect really helps as well. So there's a lot in that. I think there's a lot to unpack in that. But, psychological safety as a cultural construct, is also conducive to, to helping to, manage those sorts of situations better, I think.
Mm. Thank you, Karolina. That's really insightful. And I feel like we could keep talking about that, going on and on. It's such a big topic. It's a really interesting topic as well. I've got one final question for Hazel, and then we can move on to the Q&A section. I can see we've got a few questions there. Hazel, my question for you is, HR practitioners can at times walk a really difficult line between being the voice of the employer and the voice of employees. Can HR influence a culture of shared responsibility in the workplace, in your opinion?
Oh, I think that's a great question, Alex. And again, one that we'd have all day and we probably still couldn't solve it. But I guess in terms of the context of today, when we're talking about creating a safe work environment free from negative, disrespectful behaviours, as Warwick said earlier, what we're really doing is asking people just to be good humans. Unfortunately, whether we like it or not, employers are operating in an environment, however, where much of the burden of ensuring that respectful workplace actually falls to them. This is a really important part of what I'm about to say next, which is it then becomes critical to ensure that there's the robust policies, procedures, and frameworks in place, that workers are consistently educated in the expectations of them at work and what can flow if they don't do that. And so, in my view, HR should not have to walk a difficult line if those proper frameworks are in place. So the policies and procedures should make it clear in terms of the responsibilities that both an employer and an employee hold. So your bullying and harassment policies, for example, respectful workplace behaviours policies, a lot of that is about what is that behaviour, so that the awareness is raised. But it just as importantly is, as an individual, how are you accountable for making sure that you follow that? So being really clear with staff around that, making sure that you've got frameworks in place where people are, if they're an innocent bystander, for example, they witness a behaviour, that you've got frameworks in place that allow them to speak up about that and that they're confident that that will be resolved fairly. Again, HR can support leaders to make sure that they're aware of those policies and procedures and that they follow them. They're not always easy. We've spoken at length around the complexities that employers are facing in this space at the moment. So critically, HR can help leaders get the conversations right with individuals, making sure that they afford procedural fairness, and so that outcomes are fair for the person that has the disciplinary action, for example, taken against them, and that the behaviours are addressed appropriately in the workplace. And we're seeing that the investment in getting those sort of performance discussions right, the framework around disciplinary matters, when our clients are getting that right, they're successfully defending workers' compensation claims around, that can arise from those sorts of performance related discussions. So I guess in a nutshell, there's so much that we can do. My clear message is get those frameworks in place, make them simple, easy to understand, keep people across them. They're not a set and forget. And where something is noticed, act on it. So don't let it sort of fester away, because, the behaviour you walk past is the behaviour you accept. And the sooner you can get onto that with your employees, the better your work environment and the safer it's going to be for everyone involved.
Okay, thank you, Hazel. I think picking up from what you're saying, you've actually answered one of the questions in the Q&A, which was, what do you recommend to roll out these policies well? Building on from what Warwick said in one of the cases where they hadn't. And I hear what you're saying is that it's not enough, as Karolina said, to have it on the internet or to have an employee read a policy at the point they sign their contract and then it sits in the desk and you don't see it anymore, that you've actually got to play that policy out with education and leaders role modelling what's expected under those policies as well.
Absolutely. So it's this sort of idea that the more you talk about this, what's important to the organisation, what your expectations are, the more that it's openly discussed, it becomes very real for employees, and that's the culture, that's the standard that you've set. And so people are more likely to adhere to it. Yes, it's when you sort of let those things go. You're in a position where potentially you get more behaviours arising, but then you're also compromised in terms of the ability to address those behaviours. So we had a really good example of a client, unfortunately, where there was physical sexual harassment that did occur. They were very focused on helping the person concerned that had the treatment towards them, and that's a really good thing. But they forgot about the procedural fairness part in terms of the person that was perpetrating those behaviours. And it was a bit like the case that you were talking about, Warwick, is that it then becomes so much more complicated to address that and get them out of the workplace. If they'd had that nice, robust policy in place that ticked the boxes, that they'd given somebody the opportunity to respond to the allegations, they would have been so much, it would have been so much easier to address.
Okay, yeah, thank you. You go, Warwick?
Yeah, listen, I just want to be a little bit controversial here. I think increasingly now in this space of poor behaviour, there is a range of legislation that can become involved. If someone is, for example, the case I shared earlier where someone who's behaving egregiously in being abusive and humiliating towards another person, that is a work health and safety matter. The company is exposed there. And here's the thing, in New South Wales and in a number of other states, you're uninsured. There's no insurance there. The company will pay whatever happens there. So there's a real question as to how do you weigh that risk? And if an individual is prosecuted, they will personally pay that, not the company, not an insurer. So that's a really significant risk. Another risk is, of course, the individual who's being subjected to the abuse, that they're going to make a workers' compensation claim, and legitimately so. Now, for many businesses, the way the workers' compensation premium system works, that can be incredibly punitive. That can drive up premiums by hundreds of thousands of dollars over 3 years. So there's a risk. So when you've got an issue arising, sometimes you need to step out of that, of just focusing in a narrow sense and almost forensically work through, well, and what is the risk to reputation? What happens if, for our company, it gets out that this behaviour has been tolerated or it's been occurring within what's that going to mean for our future government tenders? What's that going to mean for our ability to, just a general, if we're in a smaller town, how we operate within that town? If we're a retirement, if we're an aged care facility and there's been suggestions of abuse by staff and you're in a regional area, what's the impact upon you in that area on your business? So they are important things. And this is where I'm going to say the controversial thing, which can undermine everything that Hazel has just said. Not completely, of course, but you say, you know what? What's the worst case scenario if we hustle this person out the door imperfectly? What's the likelihood they're going to run a claim all the way through the unfair dismissal rather than settle something at conciliation? And what is that going to save us as far as what is the benefit to the organisation as far as minimising future risk? So I think it's really important as everything that Hazel said, and I don't undermine that because it's so simple. It's not so simple. It's important that you get, it makes life so much easier if you've got those policies in place, people are inducted, all that sort of stuff. But don't ever shy away from taking a fairly objective and clinical eye over the risk and just go, you know what, we may cut a few corners at this point to avoid a much bigger risk down the track. So that would be my, I guess, my final comments in this space.
Okay, thank you, Warwick. Before we end, I'm just going to answer one more question, and then if we don't get to everybody's questions, we'll come back in writing to anyone we miss out. Warwick, I believe this question will be for you. It says, how can we hold employees to account who are long tenured? For example, they read the policy 25 years ago and feel that they are above the policy because they've been with the business so long.
Okay. You're looking at one. I think the phrase, and I dare I say it, the phrase is stale pale males of my vintage, who started in a workplace where for a boss to give an employee an earful, a gobful, was just, that was a daily occurrence, and you copped it as a junior employee. The world's changed, and so you've got people of my vintage still thinking that there's a whole bunch of practices that are acceptable and that staff have to put up with, and that's not the case. I think the reality is that I think there's some work that needs to be done by people like Karolina and Hazel as far as identifying maybe the higher risk type employees who fit profiles of maybe not better understanding the modern workplace, and spending extra time with them and making it clear, because it's as you know, Alex, we've been dealing with a sequence of individuals that fit neatly into that demographic, and all of them are almost, it's a cliche almost, for in each circumstance their defence was I've been, essentially, that's how we've always operated and it's been fine. And so why should I have to change now? That's the underlying reaction of these individuals, and they've caused havoc in each situation. And I think if there'd been a little bit of attention on each of them, all those employers could have avoided a litany of grief.
And just to add to that, do you think, say if you put someone through leadership training, even if they have behaved kind of below the law for 25 years, if you set that framework up again, I suppose is what you're saying is it's not all lost, as in you can actually reframe it up, explain your expectations, and then if they don't meet it, we're safer to progress to, say, a termination or a demotion?
Well, yeah, I mean, you can go down that path, but I don't think all is lost. When you've got people like Karolina, you know, in front of that kind of sample, yes, they might sit with crossed arms for the first 20 or 30 minutes of the presentation, engagement, discussion, but over time, the simple common sense of someone like Karolina will shift them. I think you can affect change. I think you can bring them along as long as you don't challenge their fragile egos too much, and cajole them into understanding that actually the world has moved on, and if they want to eke out that last 5 years to build up their superannuation, they really need to get with the program. So I'm not sure if I just answered your question, Alex, and if they don't, yes, absolutely. I think that's the sort of person you're going, you know what? We're going to move on this person in this situation, and we're going to take the risk because they're a hand grenade and the pin's been pulled out. So that if we don't do that, the potential for damage is much more significant.
Yeah, that did answer my question. Thank you, Warwick. We're at the end of our time. We nailed it. We're at 1 o'clock. So thank you everyone for coming along today. This is the end of our quarterly webinar series for 2024, and we will be back in 2025 rolling this out again. If you have any topics that you would like to hear from us about, feel free to reach out to us. We take constructive criticism. Warwick in particular loves hearing that. Thank you, Karolina and Hazel, for taking time out of your day and all the preparation that you've done to make this happen. We've really appreciated your insights. Thank you, everyone. And to the person that we didn't get to at this Q&A session, we'll come back to you in writing. Thank you, everyone, so much. Have a great afternoon.
Thank you.
Thanks.